Piga mapicha.
We act together, you know, sure.
The accused person, one guy Spenser to be discontinued or terminated. The application is premised to be predicated under Article 157, Subarticle 6, and Article 157, Subarticle 11 of the Constitution, Section 87A of the Criminal Procedure Code, and Section 4 and 5 of the Office of the Director of Public Prosecution. So from the outset, I wish to state that two latest Superior Court decisions have revolutionized the jurisprudence under Article 157, Subarticle 6C of the Constitution, and Section 87A of the CBC. The decisions are Pansiba Limited versus the ODPP and Abdirahman Mohammed Abdi. So the two decisions that have indicated that have revolutionized the jurisprudential topography of the powers of the DPP are Pansiba Limited versus the ODPP and Abdirahman Mohammed Abdi alias Abdi Limani High Court. Criminal Revision number E 116 of 2025 by Justice Muteti, and another one Frederick Muller versus the Kenya Human Rights Commission and ODPP, and 5 others Limani High Court Anti-Corruption and Economic Crime Petition number E 004 of 2024. That decision was by Justice Musio. More fundamentally is that the law underpinning the DPP's power of prosecution and the scope is perspicuous. Article 157A 8 of the Constitution and Section 87 of the CPC vest in the court wide discretion to accept or reject an application on the discontinuation or withdrawal of proceedings by the Director of Public Prosecution or his designated prosecutor. Corollary, this court is thus closed with the jurisdiction to entertain this application. The intended accused person faces five counts, namely the first count was making a document contrary to Section 347D1 as read with Section 349 of the Penal Code. The second count is uttering a false document contrary to Section 353 as read with Section 349 of the Penal Code. And the third count, making a false document contrary to Section 347D1 as read with Section 349 of the Penal Code. And the fourth count, uttering a false document contrary to Section 353 as read with Section 349 of the Penal Code. And the last count, demanding property upon forgery of a testamentary instrument contrary to Section 358 as read with Section 349 of the Penal Code. So the applicant, or rather the state's case, the state was represented by the Learning Council, Ms. Nora and Ms. Amisi. They urged that the application is premised under Article 157, 6 and 11 of the Constitution, Section 4 and 5 of the Office of the Director of Public Prosecution Act. They adjured that the application is derived from the judgment of the Superior Court in the case of estate of Roger Brian Robson, deceased, that is succession course number 955 of 2013, which decision was delivered on the 19th day of June this year. In their submission, correctly, was that the Superior Court had validated the will, which is the subject matter of the present criminal charges. Concomitantly, they therefore contended that upon the review of the charges and in consideration of public interest and the interest of the administration of justice, and to prevent and avoid abuse of the legal process, the DPP invokes Section 87A of the CPC. The applicant, thus the state, stated the following cases fundamentally espousing the mandate of the DPP and the constitutional relief in the exercise of that power. The cases cited are as follows. They cited the case of Praxidis Namoni Saisi, that's the Supreme Court decision. They also cited the case Ruben Mwangi, that's the DPP, constitutional petition number E216 of 2020. And lastly, Mohammed Ali Swale, that's the DPP, that is 2017 EKR. The state argued that the DPP's powers for review is continuous. Counsel also argued that based on the validation of the will by the Superior Court, the application is thus made in good faith. Flowing from the foregoing, they urged the court to allow the application. The defense case, or the intended accused person's case. The intended accused person was represented by the learning counsel, Mr. Osiemo, Mr. Litoro, and Mr. Shah. The learning counsel, Mr. Osiemo, painted the contextual backdrop of this suit. He urged that the validity of the will or testament of the late Roger Brian Robson has been a subject of litigation for the last 10 years, which culminated to the judgment that was delivered on the 19th day of June 2025. It was his argumentation that any proceedings over the same will in view of the High Court's disposition is akin to an appeal by this court, which is tantamount to an abuse of the court process. He iterated that the DPP has exercised his mandate judiciously. He vivaciously urged that the intended accused person is an officer of this court and that he does not personally derive any benefit to motivate him to uphold the will with respect to count number 1. Ultimately, he submitted that all the other charges collapses by that fact. He further urged that the court consider Article 50 of the Constitution on fair hearing. Learning counsel argued that reasons for the withdrawal has been propounded, and in the instant application, the circumstances are different because the High Court had pronounced itself where the complainant hearing participated in that proceeding, in those proceedings. He argued that after the DPP was seized with the judgment, he initiated the present application. He proclaimed that the DPP should not bend to the whims of a disgruntled complainant. Mr. Litoro Learning Counsel on his part contended that the complainant is bulldozing the DPP and her intention is to settle scores. He directed the court to paragraph 60B of that succession course judgment. He also argued that the Superior Court in the Judicial Review application number 117 of 2019, and that Republic of the Chief Magistrate City Court, Nairobi, and 3 others, ex parte, Againist Kariuki, where the High Court synthesized the issues in the Chief Magistrate the City Court matter. He reminded the aggrieved complainant victim that her remedy rests with the Court of Appeal. Mr. Shah, Learning Counsel on his part, recapitulated that the High Court held that the will is valid. He also cited Section 44 of the Evidence Act on judgments in rem. He entreated that the intended accused herein is the victim of the abuse of state machinery. The complainant of Againist Kariuki's case. The complainant is represented by the Learning Counsel, Mr. Waduki, and Mr. Shiunda, holding brief for Mr. Osungu. They have strenuously opposed and backed the application by the court. The application. Mr. Wanduki, Learning Counsel, stated that the action of the DPP is made in bad faith, granted abuse of public interest, and against the ODPP Act. His gravamen is that the DPP made a similar application in the magistrate criminal case number 153 of 2017 involving the same parties and the subject matter. The suit was discontinued when the complainant was testified. He argued that this was the second time that the DPP was making a diametrically similar application. He imputed that the DPP was protecting certain sacred cows. He further argued that in light of the provision of Section 193, uppercase A of the CPC, both civil and criminal proceedings are proceed concurrently, and therefore the succession clause cannot stimulate the instant criminal suit. He propounded that there are many issues that were not resolved in the state judgment, including the attestation of 2 witnesses who are non-existent. It was his submission that after the matter was first withdrawn, the DPP reconsidered the evidence and restituted the charges. He argued that based on the provisions of the Victim Protection Act, the complainant hearing deserves protection. He cited Section 4A and B of the Victim Protection Act on the general principles. He contended that the action of the DPP was discriminatory because the complainant was not consulted before the application was restituted. He further argued that the conduct of the DPP offends Section 9 of the Victim Protection Act on the centrality of the rights of the victim. The learned counsel cited the authority of Katiba Institute, cited the case of Katiba Institute and 8 others versus the DPP, where Judge Mohochi held that criminal prosecution has been undertaken by the DPP under the mandate conferred under Article 157(6) of the Constitution, and that the court can only interfere under Article 157(11) thereof, where any of the principle in the sub-article has been flouted. He also cited the age-old case of Stanley Munga Gimuguru versus Republic 1985 EKR, where the court enunciated an important principle that the exercise of prosecutorial powers must be fair, reasonable, and not arbitrary. He also cited the case of Zakayo Kipkemoi Arap Cheruiyot and another versus Republic, that is Nairobi High Court, miscellaneous criminal application number 6/8 of 2010, where the court pronounced itself on the application of the exercise of the powers of the Attorney General, that was in respect to the entering of no prosecutor. He also cited the case of Republic versus Wake and 6 others, that's an anti-corruption and economic crimes division number E007 of 2024, where the court held that in making such an application, there should be no suspicion that it was not made in good faith. Mr. Wanduki further submitted that the action of the DPP is meant to frustrate the advancement in the administration of justice. He reverberated that such an application should not be made whimsically and arbitrarily without the consideration of the victim. He cited the case of Republic versus Leonard Dete Sekento, that is 2019 EKR. He finally set forth that without the consideration of the victim, it militates all other consideration. On her part, Ms. Shunda, Learned Counsel, expressed their consternation by the DPP's conduct, citing bad faith and contravention of Article 157 of the Constitution. Counsel similarly gave a historical background into the matter. Predominantly, she urged that the grounds for its withdrawal were not distinguishable to the instant application. She argued that if the application is allowed, it will erode the public confidence in the criminal justice system. She submitted that after the city court matter was withdrawn, the complainant hearing raised several issues with the DPP and the DCI, who after re-evaluating the evidence found merit, thus making a decision to charge the accused person, which was communicated to them through a letter dated the 24th of October 2024, last year. So on my analysis and determination, so distilling from the foregoing, broadly, the germane issue in this application is whether the DPP has discharged its constitutional and statutory responsibilities in discontinuing the charges against the intended accused person. The golden rule is that courts ought to refrain from acts which could amount to curtailment of the DPP's constitutional power of withdrawal under Article 157(6)(c) and 7 of the Constitution. However, the court ought to carefully consider each circumstances in the interest of justice. This was held in the case of Republic versus Navif, Jama Adan and 6 others, that is 2020 EKR. Worth relating is that Section 87A of the CPC, worth restating is that Section 87A of the CPC gives this court broad discretion to accept or reject an application for withdrawal of charges presented by the learned prosecutor. In light of Article 157(11) of the Constitution, such discretion has to be exercised judiciously, taking into account the facts of each case, and in particular, whether the application is brought in the public interest, in the interest of administration of justice, and the need to prevent and avoid an abuse of the legal process. This was held in the case of George Taitumu versus Chief Magistrate to the instant case. I now posit whether the prosecutor has acted beyond his constitutional powers. In other words, has the DPP acted improperly, not for the interest of justice, acts beyond the powers vested by the Constitution, or carrying out some arbitrary objective under the guise of discharging the function of the office of the prosecution. The learned prosecutors have elucidated that the application is predicated on the judgment by Justice Timotei, which was delivered on the 19th of June 2025 in succession clause number 945 of 2013, where the judgment validated the will, which is the bedrock and providence of the charges here. My understanding of the submission is that proceeding with these charges will be an embarrassment, and more importantly, it will be akin to this court sitting on appeal of the superior court's decision, which definitely is an abuse of the court process. The arguments were buttressed by the defense counsel. I must admit expressing that they put forward excellent reasoning. Conversely, counsel for the complainants have opposed and backed that assertion. They have robustly faulted the said judgment, urging that several issues have not been resolved. I will hastily point out that this court cannot entertain and interrogate the propriety of that decision. Mr. Wandugi intimated that they have initiated the process of appeal, which was disputed by learned counsel Mr. Sheriff. More relevant, counsel for the complainant victim have invoked Section 193A of the Criminal Procedure Code. Section 193A of the Criminal Procedure Code provides that, and I quote, concurrent criminal and civil proceedings, that is the heading, notwithstanding the provision of any other written law, the fact that any matter in issue in any criminal proceeding is also directly and substantially in issue in any pending civil proceeding shall not be a ground for any stay, prohibition, or delay of the criminal proceedings. End of quote. In the case of Amir Lodges Limited and another versus Mohammed Omar Sharif and another 2022 EKLR, the court in dealing with the issue of stay of proceedings in concurrent criminal and civil proceedings in a case with similar facts and circumstances, and after discussing several authorities on the matter, it stated, and I quote, open quote, from the discussions in the superior court's decisions and other comparative decisions from foreign jurisdiction, the rule of thumb in respect to concurrent criminal and civil proceedings based on similar set of facts and circumstances is that the criminal case ought to proceed unless it can be demonstrated that the prosecution of the criminal case will either result to infringement of the rights and fundamental freedoms of the accused persons or will lead to contravention of the Constitution. End of quote. It is axiomatic, therefore, that the existence of a civil matter does not impede or bar criminal investigations and or proceedings. The distinctiveness in the instant matter is that the High Court has rendered a decision on the validity of the will. Equally notable is the very fact that the appellant process in the succession course has not been exhausted. In Kajiado High Court, in the case of Sugawara versus Republic, miscellaneous criminal application number E061 of 2023, Justice Mtuku was confronted with a similar conundrum. In allowing the continuation of the criminal proceedings, she held, and I quote, guided by the provision of Section 193A of the Criminal Procedure Code and the above authority, and taking into account the fact that the applicant has not demonstrated that she will suffer prejudice or that her constitutional rights will be contravened, it is my finding that the applicant has failed to persuade this court to grant the order she is seeking. It is my considered view that there is no prejudice that will befall the applicant as a result of the continuation of the criminal proceedings. End of quote. It is also, I've also cited the case of Republic vs. Carissa Chamber and others, that's a Supreme Court decision, petition number 5 of 2015. Be that as it may, Mr. Wandugi Learned Counsel has submitted that the complainant victim was not consulted before the application was instituted. Justice Muteti, in the case I cited, Pansiba Limited, initiated that courts ought not to ignore the plight of the victim in the exercise of discretion under Section 87A, as doing so will be improper, irregular, and incorrect in law. There has been incipient jurisprudence from the superior courts on how the ODPP ought to exercise its powers to to review its decision to charge. In the case of Banziba limited case, won by Justice Mtetia, the court went further to hold, and I quote, open court, the learned Honorable Magistrate should have noted that Section 21A of the Victim Protection Act gives the right to victims to submit information to the police or prosecution on decision on whether or not to lay a charge or to appeal or to withdraw. The request by the applicant for the ruling to be deferred was well within the law and ought to have been granted, and allow the parties to return at a later date to inform the court of any developments before the court will decide on whether or not to allow the withdrawal. The section in essence imposes a duty upon the law enforcement authorities, that includes the police and the prosecution, to seek information from victims of crime before the decision to withdraw a matter is made. Similarly, where victims, such as happened in this case, gets to know of the intention to withdraw a matter, he is at liberty to submit information to the DPP, who under Article 10, Article 47, Article 157(11) of the Constitution is obliged to consider the information supplied, make a decision on it, and inform the victim of the decision made. The DPP is not, by doing so, subjugating his authority to control the prosecution, to control the prosecutions to the victim, but simply acting within the constitutional bounds of procedural fairness in decision making and reasonableness. I've also cited the case of Associated Provision Pictures Houses Limited versus Wensbury Corporation, that is 1948, 1 King's Bench 223 at page 223. In the present case, this is the second time the DPP has sought to withdraw or discontinue the charges against the accused person. That is indubitable. I hold that to avoid such awkward situation where the DPP speaks from both sides of the mouth, now we have the sense that now we have a case, now we don't, or where the office is accused of arbitrarily and whimsically withdrawing charges against the accused person, the DPP ought to systematically consult the investigation officer and or the victims before arriving at that decision, and also in tandem with the guidelines of the decision to charge 2019. I've cited the case of Frederick Muller, I cited here in above. Therefore, having established that the victim complainant was not consulted, and pertinently that the civil succession proceeding does not bar the continuance of this proceeding, it is the finding of this court that I'll direct the accused person to take plea in the meantime as they pursue the issue of inculcating the views of the complainant, the victim, and the investigation officer. So the finding of the court is that the accused person will take plea as they explore the issue of inculcating the views of the complainant and the victim.
We have a couple of proceedings. Secretary. We'd like to study the same and take further instructions from our clients. The second application is we'd like an opportunity to interrogate the decision together with our client. If the court will be kind enough to defer for us to study it and take directions on the next course of action.
What will be making the similar application. We were ready for plea taking as directed by the court, but we will not oppose the application to defer plea taking.
That they propose to take in the future.
Well, Yana, it is settled law that the persons who got the mandate to prosecute a matter is very limited. Actually, the Victim Protection Act provides that before somebody is even admitted as a victim, the court has to interrogate. That has not been done. So strictly speaking, we don't even have a victim under the meaning of the Victim Protection Act. So the sole party that is prosecuting this matter is the DPP, who has conceded to our application to have the plea deferred. You know, it would be most unfair to have our client being prosecuted for multiple fronts. The sole prosecutors are the DPP who concedes. The complainant has no role in determining as and when an accused person takes plea. We kindly plead with this court to find favor in our application and give us time. This is about a week. You know, we will also take note of the fact that when this matter was first brought before you, the intended accused person was in London attending to a sick child. He brought himself here. He presented himself in court. And as the saying goes, your antecedents go before you. This is a person who has been willing to present himself in court as and when he is required to do so. On Monday we were here, last week we were here, we've been here throughout. If at all the court requires us next week, we will be here, as has been proven. We kindly plead with this court to find favor with our application. I'll just add that he's been out on personal bond and he's been coming forward. We are willing to present ourselves in court at a further date once we've interrogated the proceedings and the judgment. That is our humble plea.
Is seeking that I be permitted to address court for purposes of the victim. I have no intention whatsoever of taking the part of the prosecutor. I understand my role.
So counsel, I've had your application. I've considered the same. Mr. Litoro is there, Mr. Chair.
May I speak?
Yes, yes.
That week is not convenient.
Okay.
So this is a missing line. Be engaged in some official duty.
Maybe Monday, Tuesday would be all right.
I think we've indicated that both of us are engaged in official duty. We also do not want to delay the plea taking. I think Mr. Wandugi needs to be very clear, but just give us a date.
Then we can take me today then.
We urge the court for a nearer date here.
Seventh as suggested is in the meantime, Your Honor, if the accused person can, if the court can maintain the same bond terms. Thank you so much.